I'm Paul Ingbretson. I'm a full-time artist and a teacher of painting. I also served as a New Hampshire state representative for 6 terms beginning in 2003. I'm one of a number of concerned citizens, including other former and current New Hampshire state legislators, who are very concerned about the unprecedented usurpation of legislative authority by our Supreme Court in the now infamous Claremont decisions of 1993 and 1997. We've come together to produce a series of podcasts that will lay out the facts and evidence for your consideration. We'll be hearing from some of the best legal minds in our state who followed the issue from the beginning. Our goal is to create public awareness of the serious separation of powers implications of the Claremont decisions, with the hope of generating active public resistance to it and to any future such judicial overreach. Today's guest is attorney Rick Lehmann, who has served for many years as legal counsel to the New Hampshire Senate. Rick has also filed an amicus brief on behalf of the Senate in the latest court case related to the Claremont decisions. Okay, welcome to podcast number 2. What we've been talking about is Claremont 1 in particular, and the usurpation of power by the courts over the legislature is the general theme. We have a couple of very lately, since the 1990s, court cases have been going on because of the court's involvement in legislative matters, overt court activism, in our opinion. But in any case, what we're trying to do here now is begin to popularize the idea of what really Claremont was all about, all the details about it. So Rick Lehmann here, he's the Senate Counsel, and I'm having him introduce himself, and he's going to be talking about some of that stuff related to what it then leads to when the legislature begins to get involved in legislative activities. When the courts begin to get involved in the legislative activities. So introduce yourself, if you don't mind.
Sure. Thanks very much.
Go ahead and go forward.
For having me. My name is Rick Lehmann. I've been a working, practicing lawyer here in Concord for about 30 years. The thing that sort of gives me something relevant to say, I think, about the subject matter is that since the year 2000, I've served as the legal counsel to the state Senate for all but, I think, 5 years of the time since then. And in that capacity, I've been there to watch the effect that the Claremont decisions have had on the legislative process and how legislation unfolds over in the State House. As counsel to the Senate, I've had the opportunity to be involved in a lot of interesting constitutional controversies and cases involving right-to-know laws application to the legislature, the mechanics of passing bills, some of the really sort of interesting Supreme Court cases about legislative power, ones that I've been lucky enough to be involved in. So I sort of bring that experience with me. And I believe the thing that brought me to your all's attention is a amicus brief I wrote for the former Senate President Jed Bradley in the latest Supreme Court oral arguments and hearings on the latest of the Claremont decisions that have been bothering us for 25 plus years now. And the thesis of what I was writing to the court as amicus was that the court's decisions in Claremont have really changed the dynamic of how the legislature goes about its business. And I mean it this way. To me, the whole controversy about whether the court should be engaged in these Claremont decisions comes down to the question of justiciability, or whether or not the question of the adequacy of education funding is a political question reserved to the elected branches, or whether it's one that's proper for adjudication by courts. And the basic rule of non-justiciability is that courts should not get involved in something in which there are no legally discernible and applicable standards to be applied by courts. And in every other field of constitutional dimension, such as search and seizure law or what a person's trial rights are, the law is established over the years, over hundreds and hundreds of years, to let us know what the standards that the courts are supposed to apply are. And so if there's a constitutional right at issue, the court, through years and years of interpretation and adjudication, has established standards that apply. And the legislature doesn't have the ability to touch those. with the Claremont decisions in Part 2, Article 83 of our Constitution, which provides that the magistrates will cherish education, the scope of that right immediately begs the question, how much cherishing is required? If it's even really required at all by that language, and you can't really, you can't pull your car up to a pump and say, I'll take 5 gallons of cherish. And so because of that, there was no obvious standard for the court to apply. They started ordering the legislature to do things. And first they ordered the legislature to define what goes in, what are the components of an adequate education. And the court suggested, I think what they had done in Kentucky, as an idea for, this is what we think might be a good way to do it, but legislature, you go ahead and do your thing. And unsurprisingly, the legislature adopted a model that's almost exactly what the court suggested from Kentucky. And for better or worse, that created a standard. And the reason it was necessary for the court to do this, again, is because there really is nothing for them to judge that they know what an adequate education looks like. And the word adequate's not even in the Constitution. It's just a requirement to cherish. Adequate is a word that's been added to the mix from somewhere. And nobody knows what an adequate education is. So the court said, and they didn't say that they were doing it for this reason, but I think it's a fair inference. If they're going to do their job of deciding whether the Constitution is being complied with, somebody needs to create a standard for us to apply, for us meaning the court. So when the court does that, it's ordering the legislature to legislate to create a role for the court in adjudicating cases. And I can't think of any other context in which they've done anything like that, where they say you have to act so that we can do what we need to do. And it wasn't just defining what goes into a constitutionally adequate education. They did the same thing by saying there has to be standards of accountability so that we can determine whether you're really holding local school districts accountable for delivering an adequate education. And so they ordered the legislature to create a system of accountability. And they have ordered the legislature to, explain in detail what the components are since then. And so most recently, in the case that's pending in the Supreme Court now, a Superior Court judge, taking them at its word, has simply applied dollar numbers to things that are in the legislation that the court ordered to be created by the legislature and that the legislature created. And my contention is if the court has to order the legislature to establish a standard for the court to apply, then the court shouldn't be in this business whatsoever. They don't have a brief to reach out and adjudicate cases for which there are no judicially manageable standards independent of the legislation. They certainly have never asked the legislature to define what constitutes an unreasonable search and seizure, or define what constitutes an adequate number of jurors, or to define what is adequate representation of counsel. They have those standards, and those standards exist, and they're applied across the board pretty closely in all 50 states and federally. And historically coming from England, where all our laws come from anyway. So what I've seen is that rather than putting legislators in a position to exercise their best judgment and to do what they feel their constituents sent them to Concord to do, or to create an educational system that they, as the elected representatives of the people and the people closest to the voters in this democratic system, what those people want, they've instead have been striving to comply with court mandates and to be jumping through these hoops of identifying and defining and otherwise putting meat on the bones of this very thin obligation to cherish education to make it judicially reviewable. And again, if the judiciary needs legislative assistance to make something judicially reviewable, they're operating in a place where they don't belong, because they should never be telling the legislature you need to pass a law. Yeah. I had the sort of interesting experience 15 months ago of representing former President Trump over here in the federal court on a 14th Amendment challenge based on the question of whether he was eligible to run for president. That's not here to relitigate that, but during that debate, which sort of took on some national scope and happened all across the country, there was this interesting question about whether the constitutional provision that says a person who's engaged in insurrection can't hold the office of president. And the question was whether that's a provision is self-executing or not. And a provision is self-executing if it doesn't require any legislative action for somebody to go to court and enforce it. So for the examples I've given before, the criminal defendants' rights and search and seizure rights that we all hold, there's no need for there to be a law for those rights to be protected. For the 14th Amendment case, it was an interesting question whether the disqualification from office was self-executing or whether there needed to be congressional action. And I think it applies in an interesting way here too. I don't know where a court gets the teeth to act on this duty to cherish. And I would say that it's probably not self-executing, absent somebody creating a cause of action or saying legislatively saying what standard will enable somebody to establish factually that they were denied an adequate education or that the legislature didn't sufficiently cherish that person's interest or the state's interest in having an education system generally. So because we've been focused entirely on, the legislature's been focused almost entirely on complying with Claremont mandates rather than designing the best and most effective educational system, it has really, I think, diminished the quality of education that can be provided. And in this most recent case that's pending up there now, obviously so much of the Claremont discussion has had to do with relative wealth between communities and the ability to raise taxes based on property valuations. The way the case currently in the Supreme Court is structured would severely diminish the ability of the legislature to target funds towards the neediest school districts. And it would take money right out of the Claremont plaintiff towns' mouths and drop them into wealthier districts because they're doing everything based on, the poor Superior Court judge is just doing what the Supreme Court, the inevitable outcome of all of this judicially compelled legislation is that they're assigning dollar numbers to various components that the legislature was ordered effectively to include in the legislation and costing everything out. But that's being done on a per pupil basis and without regard to the fact that $15,000 in Claremont may not be the same thing as $15,000 in Bedford. Those are two different school districts that have two different sets of needs and two different sets of fiscal conditions. And rather than letting the 424 legislators act in a way that they think is the best interest of everybody, they're all scrambling to meet the obligations imposed by the court. So the heart of my contention is that they should really never have gotten into this business not because education is not important, not because it's not important for courts to adjudicate constitutional issues when they arise properly, but because they've contorted it's resulted, and I don't think anybody intended this to be the result. I don't accuse people of bad faith. I think everybody comes to it in good faith and they reach decisions, and sometimes you agree with them, sometimes you don't, but I think that the result, unintended result, is that it's really changed the way education legislation is addressed in ways that are not healthy for the educational system we have. Yeah. It's not in the best interest of all New Hampshire students.
So tell us more specifically about the Senate's difficulties, if you don't mind. Are there things that happen you're saying it in broad lines, but can you give us a specific or two?
I think that the challenge to targeting aid is the biggest risk we face now. When everything has to be done on a per pupil basis, and that number has to be something that's derived from, again, these compelled lawmaking attempts, that it prevents the legislature from saying, Bedford and Amherst and Hanover and whatever these towns, you have the fiscal capacity to do this. The state's interest in education doesn't expand to you having the best of everything. It starts at us making sure that the poorest kids can get sufficient education that they need. Because I don't think there's anybody who serves across the street in the State House who is interested in providing poor educational opportunities to students who come from not wealthy families. I mean, everybody's interested in that. It's what's the best for all of us. It's what's best for our state. But it gets interfered with by this need to identify, pay, and fund $1 to $1 last of this notion of adequacy for every student on an individual basis across the state.
Yeah. So what comes to mind when I hear all that you've said so far is the courts sound like they have sat down and they've hashed out the meaning of all sorts of stuff as if they were a legislature. In other words, that's what we do, right? The legislature sits down and we just fight over all this stuff and figure out how to do it and find the best strategies and all that sort of stuff. Right. They sound like they've already made all those decisions for us. When did they do that? I mean, is that so? You're doing very nice things by saying you're well-wishing, but
I don't think they
recognize that's what they're doing?
No,
what
I don't think they do. I think that I think they're stuck right now.
Okay.
And I mean, those first two Claremont decisions, or especially the second one in '97, Claremont II decision, really put the state behind the 8 ball because they compel education funding to unfold in a certain per pupil way and for taxes to be raised uniformly across the state as if we're one big state school district, which we're not. Right. So I don't think that they're interested in drawing out education policy up there in the Supreme Court. I really do think that they're applying their own precedents at this point. I don't think they're applying what the Constitution says. I think they're saying, we've had this accountability case, so we've got to have accountability. And in Claremont II, we said this, so it has to look sort of like this. But I think there's still a lot of leeway to design an educational system, but it just has to pay every dollar for every student, and that makes it inconceivable to do the kind of targeting that there really is the will to do over there.
Yeah. So what I'm going to do, if you guys, we still have a lot of time probably in this segment, so I'm going to have you guys, if you have questions, to go ahead and speak them out pretty loud if you have them. If you don't, let me give them this one. Why has the House never sent counsel to fight against the Supreme Court's usurpations?
I don't think that's true.
Have you? Oh, good. I'm glad to hear that.
I don't think that's true. When Betsy Miller was the House legal counselor, we filed, I think we filed briefs in a couple of Claremont cases, amicus briefs together.
Oh, cool. That's cool. Yeah.
So, I mean, the big one, the 93 and 97 decisions were before I was involved in any of this. But we've been, I think we filed some. I think Ed Mosca filed one when Speaker O'Brien Bill O'Brien was the Speaker. I would be surprised if he didn't.
Given what he's written.
Yeah.
Yeah.
So I can't really speak to why the House hasn't. I will say it's a little bit hard. The executive branch is responsible for defending the state in these lawsuits. So the primary responsibility falls to the Attorney General, but certainly in terms of defending the prerogative of the institution of the House and Senate, it's worth going up there too, and that's what I tried to do this summer for Senator Bradley, is just to remind them that their actions have effects that extend further than they may wish them to. And I don't know if they'll be interested in that message or not, but I guess we'll find out.
Well, but I guess my question might be then: is there a venue, an avenue? I mean, you have to go to the courts to challenge the courts.
Yes.
It doesn't even impress me.
Well, it's very. I tell you what, it is. It can be, and this has come up in a lot of different contexts. On the one hand, there's a feeling of going into the court, and it's definitely their home court advantage, right? I mean, you're walking into their environment to challenge something that they've done, and that can be a challenge. At the same time, I've represented a lot of sort of regular people up there, and you go about that as a lawyer with a certain kind of respect for the system and recognition of what the limits of your authority are. When you represent a whole branch of government,
right,
it makes you feel a little bit freer to go ahead and be a little more aggressive, just by way of a little war story. following the 2000 election, you may remember it was redistricting year, and Governor Shaheen vetoed the House and Senate redistricting plans, and we ended up in litigation up there for the first time when nobody quite knew what was going to happen. And the House hired this guy from South Carolina to come in and be, not the House, I'm sorry, the court hired this guy from South Carolina to come in and be its expert. And he drew the maps that they eventually adopted. And then the Supreme Court sent a bill to the legislature to pay for its consultant. And we said, Arthur Clem was the Senate president at the time. He said, I don't think so. We didn't hire this guy. He was doing a judicial function. And it fell to me to go up to the Supreme Court and look him in the eye and say, we're not paying your bill. Yeah. That's your, and they got so upset with me that Justice Nato at the time said, I think that the people of New Hampshire should see, because this is an expense for all of New Hampshire. It's not a judicial, it's not a legislative, it's all of New Hampshire. And they put the transcript of my argument where I said it's, pay your own bills, on the court. And I think it's still available on the court's website of me telling them that no, which isn't easy, but there it is.
Yeah, I want to see more of that. A lot of us do. Thank you very much, Rick, for coming down.
Sure.
If you're as concerned as we are with the loss of the legislature's control over policy and taxation in New Hampshire and wish to help, please share these podcasts with as many people as you can, and then consider donating so we can bring you and your friends even more of the important facts concerning our Supreme Court's Claremont decisions. And stay tuned. Greg Sorg will be back in the next podcast, along with Rick Lehmann, to field questions from our audience.